legal marriage relationships in contrast to criminal prosecution.
Because Justice Scalia, though, says in his dissent, don't believe it. Is he right?
No, I don't think so, because the majority conclusively responded to Justice Scalia and said, no, we don't mean this. We differentiate. They didn't leave it to speculation. But it certainly is not a hint that they're going to recognize it. And as I said, it's striking that they didn't use the right of privacy, which could have led to a compelling interest, instead did only rational basis. And in Roma v. Evans, another sexual orientation case, they also used, which had to do with a referendum and whether a referendum can prohibit political participation on the behalf of the people of the same sex, they also used rational basis. So it is clear that the appropriate test is rational basis. Now, has
the legislature refused to deal with this issue of same-sex marriage, and do we take that into consideration in deciding this case?
The answer is you should not take it into consideration. The issue should be whether or not there's a constitutional compulsion, as long as there's a rational basis. That should discharge your responsibility. But with respect to same-sex, we listed on pages 54 and 55 of our brief all the changes that have been made by the legislature in furtherance of same-sex relationships. Have they approved marriage? No, they have not. Has the issue been brought up? I couldn't say. I'm sure it is raised, but the fact that it's not passed over some period of time doesn't mean there's a constitutional compulsion to give them relief when there is no constitutional basis for it. There is also a hint, under equal protection, that you've created another tier. I am not sure where that comes from. And for this very reason, I've looked at all the equal protection cases where you have reversed. You apply the same standard. If it's compelling, fundamental, heightened scrutiny, sexual discrimination, I'll deal with that in a minute. And rational basis has always been the same, and your court has said it's the paradigm of restraint, that if it's fairly debatable, you shouldn't touch it, as has the Supreme Court, because then you become a super legislature. I don't know where they get this distinction between personal rights and economic rights. Hope versus Paralysis, which had to do with reproductive rights, you applied rational basis, same test. In a case, in McMinn, let me deal with McMinn since they rely on it. That had to do, as you know, with the town of Oyster Bay and the zoning regulation, which differentiated between people of the same blood, where they could have an enormous household, and people unrelated could only be limited to 2 people. And you said the purpose of the regulation, which was given by the town, was to reduce noise, reduce overcrowded parking, and make the area more attractive. And your point was, how does excluding them solve that problem? If you have a large household of related people who are similarly situated to a small, what difference does it make? They're both increasing the problem. And so you apply the general test. I have never seen you apply a different test. Now,
well, all courts apply stricter scrutiny to certain categories, and isn't it to categories of people who are most likely to be the victims of abuse and discrimination?
Yes.
And aren't homosexuals almost a classic example of people who've been abused and discriminated against for a long, long time and who need special protection?
And the answer is no, for this reason. Have they been discriminated against? Yes. Do they need protection? No, because under Kleberg, which is exactly the test you posit, the issue is, do they have political clout? If in that particular case it was...
Well, but black people aren't without political clout either. We still apply strict scrutiny.
Yes, but that's a historic. Yes, but that's a historic fundamental basis. The difference here is that we're asking about creating a new right, which is either fundamental or strict scrutiny. And what Kleberg says is you should be reluctant to create new rights where they have political power because they've shown they can use the legislature, and you don't want to act as a super legislature and take away their ability to participate in the political process. And in that particular case involving mental retardation, the court held that they reversed the circuit, which had held strict scrutiny, because that was a class that had been discriminated against. But then they pointed out that that class had been successful in obtaining legislation.
Have mentally retarded people really been victims of the same kind of discrimination that homosexuals have?
It may be a different type, but it still doesn't deal with the issue, are they politically ineffective? And the truth is, they are politically effective. Indeed, my client has gone on record as saying he would support, before the legislature, a legislative change. It's hard to say they're politically ineffective. They do not meet the test under Cleburne, Your Honor. And that is, and also there's a general reluctance to create new rights, and the reason for that is because you don't want to intrude on the legislature's discretion. In effect, these individuals are not similar. The definition has been, the reason it's fundamental is it's deeply rooted. And I do not believe there is any constitutional compulsion to include them. And before I conclude on sexual discrimination, I'm only going to make a very brief comment. I don't understand it. As I understood sexual discrimination, it means a man is treated differently than a woman. There's some disability because of the sex.
It's been held, hasn't it, that male-on-male harassment or female-on-female harassment is sex discrimination?
I don't know. No, I really
well,
don't.
I mean, it's true, isn't it, that I mean, there's discrimination in a literal sense. One of their female clients can get married if she marries a man, but not if she marries a woman.
I have to disagree with you. It's a discrimination based on sexual orientation, but the female is not being treated differently than the male. That is the aim of the sex statute, the sexual discrimination statutes. Both of them can get married under the definition. It is true they don't meet the definition, but that's for the legislature. The fact that they can't marry each other...
But the definition takes sex into account.
No, it's certainly, Your Honor, because the male is being treated exactly as the female is. I can't get married to a male. Judge Kaye can't marry a female. We're being treated exactly the same. That is not that. Well, the purpose of the legislature was not to change that.
Well, isn't this another one of those things that depends on how you word it? I mean, Judge Kaye can marry you, subject to maybe some impediments. I can't. What's the difference?
To be candid with you, I have never seen. I have never been able to follow this argument. I have read it. I admit an ignorance on my part. I have read the cases. I don't see a connection. I think I've exhausted this particular issue.
Yes, I think we should go down a different road.
The only other point I do want to make is that Traynor is not just an old case. Even as recently as 1970, there was an individual, and this really highlights why this is appropriate for the legislature. There was an individual who committed a crime against his wife, and he wanted the benefit of family court prosecution because I guess the rehabilitation portion was easier than if it was in criminal court. And essentially what he argued was his status was equal to a marriage as defined in the statute. He said, I have a common law marriage which was recognized outside of New York and should be recognized inside New York. And this court said, it's up to the legislature to define marriage. Go to the legislature. But in the meantime, you don't meet the definition. Therefore, citing the very case I cited about a man and a woman and the legislature defines who can marry, the court refused to give him the benefit of the Family Court Act. This is really a classic redefinition. And it is one where I do not believe they are similarly situated. They want to get the benefit of a historic definition. There's only one place for that, the legislature. I believe that's been reflected in each of the appellate division decisions, and we ask that all those orders be affirmed.
Thank you, Mr. Kerner. Mr. Schiff.
Judge Kaye, may it please the court. Let me talk a little bit about, our bottom line here is that if there are going to be changes, it ought to be done by the legislature. And I think there have been bills, all sorts of bills. I don't think there's been anything very active as far as I can tell, although I haven't done real research on that question. But I would say that experience shows that while matters are in litigation, and this has now been in litigation for quite a while, the legislature is very reluctant to act, and it's not likely to. Now, I think when, after this court decides, hopefully in our favor, there's every reason to think that that may change. They won't have the excuse that the matter is in court. And, one case in point that I remember, a number of years ago, I argued in the defense of the health department's smoking regulations, and we lost on the ground that the health department didn't have the authority to do that. And very soon thereafter, the legislature, because they thought it was right, adopted probably rules that or a statute that was even more stringent than the regulation. But there wasn't any reason for them to act, and there have been lots of, while things were pending in court, and there are a lot of other examples of that sort. I think I'd like to talk a little bit about what we have said, and I think the Third Department has said, as to why the law is rational. And we believe that the state has had a long interest in channeling opposite-sex relationships into marriage. And this is so that there would be a full family rather than there would be no family for that. And so that this is in the state's interest, and it's also in the family's interest, but both economically and socially. And since opposite-sex couples are the only ones that procreate by lying next to each other, and we think that this differentiates the situation materially from the request that the same laws be applied to same-sex couples. Frankly, I'm not sure, it seems to us, that they simply aren't comparable. The equal protection requires a comparable situations. We think this is not comparable. And in large measure, I would say that we think that the Third Department's decision does a splendid job in expressing our views. I'd like to say something about whether there's a fundamental right under due process. Judge Smith, you have asked, well, isn't it a matter of how you define it? And I suppose it is, but I think it's quite clear, in looking at all the cases, the ones that say that marriage is a fundamental right, it's a recognition that it's always been connected with procreation and the preservation of society. So if you're looking at a fundamental right, you should look at what the basis for the assertion of a fundamental right has been. And I only go back to the Skinner against Oklahoma, but then you have the Loving case, and you have a number of others that they cite,
what about Turner
against Safley.
Yeah, well, what does Turner have to do with procreation?
Well, at that point, the court had, I mean...
That case held, didn't it, there's a constitutional right for people who can't possibly procreate to get married.
Well, they did indicate, as Mr. Kerner said, that there was a prospect of that in the future. So, I mean, at that point, the court had consistently talked about the fundamental right relating to the marriage between a man and a woman, and of course, historically, that's been how marriage has been viewed. And a fundamental right, both by this court and the Supreme Court, is something that has been deeply rooted. So, if anything's been deeply rooted, it's the marriage between man and a woman, and frankly, as the Third Department pointed out, and as we pointed out to them, I think they're simply asking for a redefinition of marriage. And that is something that is really appropriate for the legislature to do, not for the court.
Well, but the legislature obviously could not constitutionally redefine marriage to mean only marriage between people of the same race. Correct? So it's not a marriage unless the two people are of the same race?
No, of course not.
Is there any real difference between a definition and a substantive limitation? I mean, isn't the state in substance saying only people of the opposite sex can get married?
Well, the question of a fundamental right is you have to see what's the basis for it. It hasn't been historically that just because two people love each other, It's because there has been this relation to the possibility of the procreation. I mean, it's intertwined as to
really
how the
saying-
court said what a fundamental right is.
Yeah, but what you're really saying, aren't you, is that the definition of marriage to include only opposite-sex couples makes sense, that it's a rational definition. But that's different from saying that that's the definition and that's the end of the story.
Well, I think it's irrational, and I think it's also what it has been historically viewed.